Hello again. Like many people, I am uneasy about the cancellation of local elections, which smacks of a dictatorship in action. But surely such an idea is fantastic. We have Magna Carta and habeas corpus to protect us, together with democratic elections, juries, and so on, and all sorts of safeguards. It couldn't happen here, could it? The truth is, none of those ancient safeguards against somebody in Britain ruling in a tyrannical fashion have any real meaning at all. Things like habeas corpus, which supposedly stops the government from grabbing whoever they wish and holding them indefinitely without trial, are dropped in a moment if it seems to the government of the day necessary or even useful. We've seen this present government cancel elections on the flimsiest of pretexts. And we know too that they have the power to abolish trial by jury. But is there anything at all to prevent them going the whole hog and rounding up people they think are dangerous and putting them behind barbed wire indefinitely without the right to a trial? The answer is that not only is there nothing to stop any government in Britain from doing so, but it has been done more than once in the United Kingdom within living memory. I remember it happening. Let me explain. Magna Carta promises us precisely nothing at all and will be overruled by any British government which feels in the mood for doing such a thing. In short, it doesn't guarantee anything and is of no practical significance, binding the government to nothing at all. As soon as the concept of habeas corpus becomes inconvenient or clashes with the urgent needs of the moment, any British government would drop it like a hot potato. Only a very few instances are needed to show the truth of this assertion. Three from the 20th century should be sufficient to make the point. In 1914, following the outbreak of war with Germany, the Defence of the Realm Act was passed. This made provision for the arrest and imprisonment of anybody living in the United Kingdom who had been born in Germany. Thousands of men were detained and held in often poor conditions behind barbed wire in what were openly called at the time concentration camps. One at Camberley in Surrey alone held 8,000 prisoners. These men had no recourse to law, and some were held for over 4 years. They weren't prisoners of war, they were civilians. They were people working as waiters in hotels and so on. During the Second World War, an even tougher line was taken by the government of the time. In August 1939, before war had even been declared, Parliament was recalled from its summer recess in order to pass the Emergency Powers Defence Act. A notorious provision of this act was Section 18B, which gave the authorities power to lock up anybody they wanted to, whether British or any other nationality, for as long as they wished. Habeas corpus was suspended without a second thought. Sir Oswald Mosley, the leader of the British Union of Fascists, was perhaps the most famous victim of this legislation, but there were many others, some of them quite prominent men and women. One notable example of the use of this draconian act was the arrest and detention for 3 years of 70-year-old Admiral Sir Barry Domville, who had been unwise enough to express sympathy for Germany before the start of the war. The situation in Northern Ireland was even worse than it was in England. There, the Special Powers Act of 1922 gave the authorities in the province the power to do whatever they wish, ignoring habeas corpus at any time. When a bombing campaign was launched by the IRA just before the Second World War, the Special Powers Act was used to arrest suspects and hold them indefinitely. On December the 22nd, 1938, 34 men were arrested on suspicion of being members of the IRA. These men were not charged with any offence, nor were they brought before a court. Some were not released until after the war had ended. In other words, men were held without access to the courts for 7 years in the United Kingdom, without anybody worrying in the least about Magna Carta and habeas corpus. It may be argued that such cases might be justified during a world war, but there are more recent cases of British governments chucking Magna Carta overboard when it gets in the way of what is seen as good governance. In 1972, the so-called Troubles in Northern Ireland became so violent that direct rule from Westminster was introduced. A minister in London ran the province and regulated the use of various laws to try and suppress the IRA. On the 30th of March 1972, the Northern Ireland Temporary Provisions Act 1972 received royal assent. This meant that the British government assumed complete and direct responsibility for running Northern Ireland's affairs. At once a problem arose. All the specific legislation relating to Northern Ireland was now set aside, including the 1922 Special Powers Act. This was the legal mechanism which allowed the authorities to detain men without trial. From now on, arrested prisoners would have to be brought before the courts and tried for offences in the same way as they were in the rest of the United Kingdom. This was unthinkable, and so William Whitelaw, the first Secretary of State for Northern Ireland, at once and without a second thought signed the Detention of Terrorists NI Order 1942 bracket 1972 number 1632 NI 15. This order, which was made under the new Northern Ireland Temporary Provisions Act, did away with habeas corpus and allowed men to be arrested and held without trial for the rest of their lives if necessary. Nothing more clearly indicates just how meaningless is the lip service paid to the Magna Carta and the ease with which habeas corpus can be disregarded when it is felt to be necessary or desirable. A total of 2,000 political prisoners were held under the law passed in 1972, and nobody seemingly even noticed that a coach and horses were being driven through Magna Carta. I don't mean to suggest, by the way, that Keir Starmer is actually planning to round up his political opponents and threw them in the concentration camps. What I am saying clearly is that there is absolutely nothing in the British Constitution which would prevent him from doing so if he wished. The law can be changed, abandoned whenever the government wishes to do so. If Keir Starmer did want to start acting like a dictator, nothing and nobody can prevent him from doing so.